It's fun to be here. I enjoy the opportunity to chat with you guys today about this work. So today I'll be talking about some of the work that I've done on options value and natural resources over the past couple of years, and also on a challenge that was brought by an environmental group, the Center for Sustainable Economy, to the Obama administration's most recent plan for offshore oil exploration. I'll talk for about half an hour and then we'll do some Q&A. All right. So I'm going to cover 4 topics. One is what is the Outer Continental Shelf, the OCS, and why does it matter, right? So the OCS has environmental characteristics that are associated with substantial risk from offshore exploration. And it places, so the OCS is really in a category with the Arctic National Wildlife Refuge, at the heart of debates about oil extraction in the U.S. And specifically about environmental impacts. Okay? Because of these environmental impacts, there's a substantial history of regulation of OCS, so I'll talk a little bit about that kind of legal and regulatory regime governing OCS development. We'll take a little detour then to talk about the theory of option value and how it relates to natural resource exploration, in particular the OCS development. And then finally I'll talk about the Center's challenge to the current drilling plan, which is based in part on an article that I wrote that was published last year in the Colorado Law Review. I argued that case for the Center in the DC Circuit in September. We're awaiting a decision. Okay, so let's just start off on what is the OCS and why does it matter. So I looked it up on Wikipedia, and according to Wikipedia, the Outer Continental Shelf is a peculiarity of the political geography of the United States, right? So just to kind of state that another way, the Outer Continental Shelf is really a legal construct rather than a basic kind of physical phenomena in the world. Okay, so geographically, a continental shelf is an area of shallow water that extends from the edge of a continent, right? So on this image, it's on the upper left-hand corner. It tapers down and gradually kind of levels off until you get this abyssal plain, areas of very, very, very deep water. Okay, so that's geographically what a continental shelf is. We also have a legal definition of what a continental shelf is, and when lawyers get involved, things typically get a little bit more complicated, right? This is the definition from the UN Convention on the Law of the Sea. It's a definition of a continental shelf for those purposes. Now, why do lawyers get involved? Lawyers get involved because this definition helps define rights to some very important economic resources, and probably most importantly, the rights to minerals under the seabed floor. So let's just do another definition. I'll leave the UN one for you guys to work through on your own time. This is the definition in US law, and this is from the Outer Continental Shelves Lands Act. Okay? So by statutory definition, the Outer Continental Shelf are areas of submerged land, so lands underwater, that are subject to the jurisdiction and control of the United States, right? So this is roughly our exclusive economic zone, which is 200 miles from the shoreline, 200 nautical miles, that are not navigable waters. And then navigable waters are defined in the Act here as basically the portions of waters that are under state control. And typically that extends out 3 miles from shore. So basically the Outer Continental Shelf is from 3 miles out to 200 miles from shore. All right, so those are some legal definitions. What this all boils down to really are a bunch of lines drawn on a map where the US government is the lead administrative authority. So when you apply these various definitions, you get something that looks like that. That is the Outer Continental Shelf as legally defined. And what that is a big chunk of the oceans where the US government, like I said, is the authority. Now, most of the OCS is actually not subject to leasing right now. It potentially could be, but it's not subject to current leasing plans. But the areas that are, you have 5 areas. 2 are the Chukchi Sea and the Beaufort Sea up in northern Alaska. You have Cook Inlet in southern Alaska, and you have 2 regions in the Gulf. Okay? So those are the areas that are subject to leasing under the current 2012-2017 leasing program. Now, drilling activities can have serious environmental consequences. The Bureau of Ocean Energy Management in the Department of Interior, right, that's the agency that's charged with actually administering the OCS, in its environmental impact statement for the most recent leasing plan, it notes the diverse marine and coastal environments and the tremendous diversity of habitats and biota, right? So you have really a huge diversity. We have a couple of examples here, the Mississippi sandhill crane, which is endangered, endemic in the Gulf region, the humpback whale, which is in both the Gulf and in the Alaska regions. And the environmental impact statement also notes a wide range of risks associated with routine drilling operations. Okay, so these include liquid and solid waste disposal, harmful air emissions, and noise pollution, which especially affects marine mammals. It also includes physical impacts like strikes from ships and air traffic. So these risks matter in part because of the close proximity to ecosystems and species, right? So here is a blow-up of Cook Inlet in southern Alaska. And what you can see is that a big chunk of Cook Inlet, which is subject to leasing, is actually designated as critical habitat for the beluga whale. So there's an example on the upper right there of the beluga whale. It's a cute little guy, the beluga whale. So the beluga whale population in Cook Inlet is in a really serious state of decline. So in 1979, there were 1,300 animals documented. That's fallen to 280 in 2011, so that's a very serious decline, and they're still in a state of decline there. Now, critical habitat under the Endangered Species Act is a designated area that is found to be essential to the conservation of an endangered or threatened species, right? So because of this close proximity to drilling activities, even routine operations in the outer continental shelf can have substantial effects on habitats and species. So there are human effects as well. So this here is a study from 2008. It was published in the Royal Swedish Academy of Sciences on the effect of coastal wetlands for hurricane protection, right? And so basically what they do is they do like a regression analysis of major US hurricanes and then look at the effect of wetlands on reducing hurricane damage. What they find is there's a substantial effect. The headline finding is that the US wetlands provide over $20 billion a year in benefits in terms of just merely in terms of hurricane protection from hurricanes. Right? So there's a substantial value to these wetlands. And this relates back to the OCS and drilling because of the potential effects from drilling on wetlands. So what we have here, these images, are from the Bureau's, again, environmental impact statement, and it shows the concentration of wetlands in the Gulf Coast. That's the top image. And the lower image are the paths and landfalls of major hurricanes in the same area. So you can see that wetlands are doing some important work in terms of protecting the Gulf Coast region from hurricane damage. And the environmental impact statement also notes the range of risks to wetlands associated with oil exploration. That includes air and water pollution, spills, spill cleanup activities, and there is potential for substantial damage. Okay, so all of that goes to routine and expected oil spills, but of course the really serious threat is from major catastrophic spills. So these images here are of course from the BP Gulf Coast oil spill in 2010. The spill started when the Deepwater Horizon, that's the picture on top, exploded, killed 11 people. It started a leak that lasted for 87 days before it was finally sealed. It released over 4 million barrels of oil before it was finally closed. That's according to the US government. Some people say more, some people say less. The wildlife toll was really, really severe. A recent study estimated that between 600,000 and 800,000 bird deaths were associated with this oil spill. And of course, there was a massive economic effect, which BP has borne part of and of course is socialized to some extent. So BP is paying tens of billions of dollars out in various cleanup costs and claims. And of course, there's some associated litigation costs as well. And that's, of course, still being litigated. So interestingly, this spill was not actually on the continental shelf as it would be geographically defined. It was in the outer continental shelf as it's legally defined. But they were drilling in about a mile of water. Okay? So it was about a mile depth of water before they went down. So that was part of the reason. So that wouldn't be defined as a continental shelf geologically. But that's part of the reason why the spill was so hard to clean up, because it was in such deep water. Okay, so that's what the outer continental shelf is. That's why it matters and why we think about it sometimes. Okay, so now I want to talk a little bit about the legal history of development of the OCS and the legal regimes that govern it. Okay, so here we have some images from ancient history, 40 years ago, and a quote from one of the first cases that construes the modern OCS Lands Act. OCSLA is what it's typically called. So the two big cross currents behind the modern contemporary version of OCSLA are environmental concerns associated with drilling. So here we have the Santa Barbara spill of 1969, which really put the concerns about the environmental effects of drilling on the map, so to speak. It was national news. It was the biggest oil spill at the time. At the same time, or roughly contemporaneously a few years later, we of course had the 1973-1974 oil embargo, huge economic toll associated with that oil embargo, and that highlighted the danger of relying on imports for this basic ingredient of our functioning economy, right? So what you have on the one hand is environmental concerns, and on the other hand, a push to expand domestic energy production. So if that sounds like vaguely familiar, right, that's exactly the same political dynamic that basically drives a lot of environmental issues today. And it's been in place basically for at least half a century, okay? And so these are the two cross currents that are still with us, but really served as the backdrop for the revision to OCSLA that we have with us today. So OCSLA tries to resolve this basic conflict by continuing to open lands to development while subjecting drilling to a very substantial planning process and various environmental controls. So in the words of the Act, they're doing a balancing, right? So here, I'll just read briefly from the purposes of the Act. The OCS is a vital national resource held by the federal government for the public, which should be made available for expeditious and orderly development subject to environmental safeguards in a manner which is consistent with the maintenance of competition and other national needs. So just from that statement of purpose, you can hear this basic conflict at the heart of this legal regime. So I'll talk a little bit more about what OCSLA requires, but on top of OCSLA, you've also had a series of moratorium that have been placed on leases by Congress and by presidents kind of over the years. So starting in 1982, Congress started to do these moratoria. George H.W. Bush put in a presidential moratoria, which he had the power to do under OCSLA. That was extended by Clinton. But in the lead up to the 2008 presidential election, there was a spike in gasoline prices, and gas prices became an issue of kind of national conversation. And President Bush lifted the presidential moratorium, and then a Democratic Congress let its moratorium expire in the fall of 2008. So that opened the door for pretty extensive drilling. After the BP spill, there was a brief moratorium in the Gulf, but that has also lapsed. Okay, so that's like the basic structure of the legal regime. So here is a little bit more on OCSLA. So the heart of the 1978 OCSLA amendments was a planning process that's described in Section 18 of the Act. So the planning process, this planning process was at the heart of the Center's challenge to the Act, or to the agency's leasing plan. So what Section 18 requires is every 5 years to develop a leasing program. And the leasing program needs to include all of the OCS areas that are potentially subject to leasing, along with so they have to have a list, and then they have to do an analysis of various statutory factors as part of the leasing program. Okay? Now, they come out every 5 years, and they're typically the subject of litigation. Not every single leasing program has been subject to litigation, but nearly every single one. So I want to just call your attention to a couple of important features of the Act, or the Section 18 planning process. So in Section 1A, the Secretary is required to consider economic, social, and environmental values and explicitly notes certain types of impacts. So specifically here we have like the marine, coastal, and human environments. And that language has been the subject of litigation. Section A2 sets out kind of enumerated factors that the agency has to consider, including an equitable sharing of developmental benefits and relative environmental sensitivity. So our litigation included some discussion of equitable sharing, and then the relative environmental sensitivity has been a major, has been subject to litigation in the past. And then finally, Section A3 requires the Secretary to strike a proper balance between kind of competing social priorities. And the way that the Department engages in this balancing inquiry is through a cost-benefit analysis. So basically, since the beginning, the agency has done a cost-benefit analysis of its leasing program, and that's how it complies with Section A3. Okay, so that's the OCSLA planning process. So before I get into the kind of nuts and bolts of the Center's challenge, I want to take a step back and talk about the substance of one of the claims, which was the subject of this article that I did. So the piece on this slide here that's noted is by Ken Arrow and Anthony Fisher. It was published in 1974. In that piece, they lay out the theory of something they call quasi-option value in the environmental context. And in somewhat refined form, this quasi-option value was basically the basis for one of the Center's main claims. Okay, so I personally got interested in this issue in September 2008 with this op-ed in the New York Times. This, again, in the lead up to the presidential election of 2008, gas prices were a subject of national controversy, right? And this piece by Bob Hahn and Peter Passell appeared in the Times. And what they do is they argue that drilling offshore and in Alaska, in the Arctic National Wildlife Refuge, is basically an economic no-brainer, that it makes no sense not to drill because the benefits of drilling are basically around $1 trillion, and the costs are in the hundreds of billion dollars, and trillions bigger than a few hundred billions, and so therefore we should drill. And that's even including the intangible costs associated with kind of environmental consequences, right? And they actually take a version of this, they boost it up, and they publish in a peer-reviewed journal. And again, their argument was that it's just flatly irrational, economically irrational, not to drill in the OCS. So what surprised me about this article and the subsequent piece was that Hahn and Passell completely ignore quasi-option value. They just don't even talk about it. As I started to dig around this issue a little bit more, I found that Hahn and Passell were in good company, because the Department of the Interior, in its economic analysis, it also completely fails to account for quasi-option value. And that surprised me. Actually, I thought it was like completely nutso that they would do that. Because this methodology has been with us for 3 decades in the peer-reviewed literature. It's in the peer-reviewed economics literature, it's in the peer-reviewed finance literature. Versions are used extensively by private companies when they make investment decisions. And it's just kind of mind-boggling that the US government, holding this massive asset on behalf of the US public, fails to do this basic component of economic analysis. Okay, so that's all a little obscure if you don't know what quasi-option value is, right? So what is this? In essence, quasi-option value is the value of information that one acquires during a period of delay, right? When you wait to make a decision, all right? So quasi-option value is relevant whenever there's uncertainty about payoffs or costs for any type of investment, right? If the investments are irreversible to some extent or another, and if you acquire information when you wait. All right? So whenever you have those 3 conditions, uncertainty, information, and the acquisition of information, uncertainty, irreversibility, and the acquisition of information, you have a setup for quasi-option value. Okay? Now, this, in the environmental context, this option value is basically the same as the value of holding options in financial markets, right? So you're folks are familiar with the idea of holding an option in a financial market. The reason you hold an option rather than an underlying asset of any sort, including like a stock, is because of this option value, because of the information value of delay. And in fact, you can analyze environmental options with exactly the same mathematical models that you use to analyze options in financial markets. All right? So in the offshore context, the US government holds leasing rights, which it can sell at any time. It can delay. It's actually, one of the nice things is that it's costless to store all that oil under the ground. You don't have to pay anything to store it. The benefits of leasing are uncertain because the price of oil changes, right? The costs are uncertain because there's uncertainty about the environmental consequences of drilling. There's uncertainty about technological development, right? Of both drilling technology and cleanup technology. And there's irreversibility. Once the government sells the lease, that is hard to unwind. It's hard to go get that lease back, okay? And so if we delay that leasing decision, we gain information in the interim, and that creates quasi-option value, all right? Now, like I said, private companies take this option value into account all the time. So one indication, so in derivatives markets, folks have heard of derivatives, right? Many of those are different types of options. And I just looked this up. Outstanding derivative positions have been estimated to stand at over $50 trillion at any given time. So this is a rather large financial market. 50, did I say 50? That's five. Actually, it's 500. It's 500 trillion. Right? So it's a huge, mind-boggling. So those are positions, right? Okay, but even putting that to the side and just focusing on offshore exploration, private companies take option value into account when they make their own leasing decisions, right? So companies purchase leases in the outer continental shelf, but they don't always exercise. They don't always go in and do drilling right away. And so you can just observe this. We have data on all this stuff. So what are companies doing when they just hold on to these leases? Why pay for a leasing right if you're not going to exercise it? And the reason is because they're taking into account option value. They're watching the price of oil, and as they gain information while watching the price of oil and maybe doing some technological, doing some investments in technology, scoping things out, seeing what other people are producing at what cost, they learn something, and then they make a decision about whether to exercise or not. And in fact, economists who are interested in this topic have gotten data about the kind of behavior of private companies in developing these leases and prices. And the best explanation for what private companies are doing is internalizing a portion of the option value associated with them exercising their leasing option. Okay, so the Hahn and Purcell mistake here is small potatoes, but the big problem is that Interior is doing exactly the same thing, which completely undermines its economic analysis. So as Jacob mentioned, at the time that this came out, I ran a center at NYU focused on economics and regulation. So I kind of started to bug the agency about it. I wrote comment letters. I sent them a petition for agency action, which they duly denied. I wrote a report. I got really mad, and I wrote a law review article. That's what you do when you're really mad. And in that piece, I kind of lay out an extensive economic and legal argument for why Interior needs to account for this option value. And why I think, and I say in this article, why I think the failure to do so exposes Interior to substantial litigation risk. Okay? And for what it's worth, Interior actually did listen to part of that argument. So in its 2012-2017 leasing program, put out a draft. I did comments on the draft. And in the final version, they actually accounted somewhat for option value. They did what's called a hurdle price analysis. So basically it was like, what is the minimum price of oil that it's worthwhile for us to go forward, given that we have some option value that we're giving up? So that was good, but it only took option value with respect to price uncertainty into account. Okay, so they looked at how the price of oil and variance in the price of oil, and they said, okay, there's going to be some option value associated with that. But the problem with that analysis is of all of the forms of uncertainty, the one that you can expect private industry to account for in its decision is price uncertainty. They're not going to worry about environmental and social cost uncertainty. That's in fact why we have a government regime, because private companies don't internalize those costs. And so the agency failed to take that into consideration. And the Center for Sustainable Economy, who, I was in an academic institution. We don't have any members. This center is like a real environmental group, right? They have members. A couple of the members that, we talked about in this case, Diane Wilson, who runs a commercial fishing operation in the Gulf. This is a third generation family-run operation in the Gulf. Bob Shavelston, who lives on the coast of Cook Inlet, right? So they have members all over the country. And those members are, it's okay, you know, they'll be okay. Ms. Wilson and Bob Shalveston will be fine. Well, if they win, they'll be fine. So in any case, we had the center had done comments. The center had incorporated kind of this option value argument, some of the work that I had done, into its comments. And ultimately, they decided to litigate the leasing program because of a failure to include a reasonable economic analysis as required by Section 18, policy integrity, where I worked, and this regulatory policy clinic that I directed at NYU at the time served as co-counsel, and we brought suit in the DC Circuit. Okay, so the challenge itself. The center raises several challenges under OCSLA and also under the National Environmental Policy Act. One was the failure to account for for environmental and social uncertainty in the options analysis, right? So the argument was that that failure irrationally biased the program in favor of too much leasing too soon. That wasn't the only challenge, so there were some other arguments that we made. One was the fact that Interior's economic analysis completely fails to account for the degradation to wetlands associated with kind of onshore infrastructure. So one of the main effects from offshore drilling actually is the infrastructure that's needed to carry that out. And in their economic analysis, they actually make an assumption that the wetlands losses will be zero because of mitigation measures that will happen downstream during the permitting process, which is like grossly irrational thing to assume. So that was another thing that kind of made up a portion of the challenge. Another element of the challenge had to do with a regional transfer of risk and the agency's failure to account for the regional transfer of risk in its economic analysis. So if you remember, Section 18 included a requirement that the agency consider an equitable balance, right? And the kind of equitable distribution of risks across regions. And what Interior did is it failed in its economic analysis to recognize this transfer of risk. So just to show kind of how that plays out. If you don't drill, if we reduce the amount of drilling that we do, it's going to increase imports, right? And those imports come in tankers, which go into certain parts of the country. We get really ports in California and along the Atlantic coast. So that tanker traffic is associated with some environmental costs, right? There might be spills and so on. And so that's the environmental cost of not drilling, but it occurs in particular regions. When you drill, you reduce those environmental risks, but you create new environmental risks up in Alaska, right? And in the Gulf. And in Interior's economic analysis, they treated the opportunity costs of not drilling, right? So the environmental costs associated with drilling, they treated those as though they occurred in the same regions where the cost of drilling would occur, which is, again, bonkers. It completely obscures this important reasonable or this important regional transfer of risk. Okay, so those were three of the challenges. There were others. From an administrative law perspective, this is not an easy case because agencies get pretty broad discretion in how they carry out complex analyses of various sorts. But what I think is a saving grace of this challenge is that we're not arguing about like the details of how an economic model is executed by an agency. Rather, what the challenge is about is huge classes of value, like option value. So we're not arguing about how they did option value. We're arguing about a big chunk, economic and social uncertainty. Or I'm sorry, environmental and social uncertainty. And in the past, where Interior has lost on these challenges, it's been in that kind of context where they've just irrationally excluded a category of value or an entire class of value. They just did it in a really irrational, they examined it in a really irrational way. So, like I said, I argued the case in September. The government made some very aggressive arguments on standing in that case, which we can talk about in the Q&A if you guys are interested. But I think there was some, and we did get some questions from judges on standing. I think that there was also some skepticism on the part of the bench on the government's argument, because the government was really arguing for very broad discretion to just kind of do the economic analysis the way it wants, and the court has not given it that discretion in the past. Importantly, again, from an administrative law perspective, the agency never explains why it takes price uncertainty into account for options analysis, but not environmental and social cost uncertainty. And it's the failure to explain its choice there that I think, if anything, is going to create some problems for the agency. So just briefly on what the consequences of the litigation would be, depending on the outcomes. If the center wins on some of its claims, the likely remedy is a remand to the agency, right? So the plan would have to go back to the agency. Further lease sales that are contemplated by the plan, so they've done some leases already, but they haven't done all the leases that are contemplated. So those may be postponed while the agency does further analysis. These existing leases are probably not going to get canceled, though. In my view, if the agency does a good job of its reanalysis, there should be some substantive changes to the leasing plan. And what those would include is a reduction in the total volume of leasing and a shift from areas where there's greater uncertainty about the environmental and social costs to areas where there's less uncertainty, where we have a better picture of what the consequences are. Also, just kind of finally, in terms of the kind of broader implications, I think this is a very good case of an environmental group using economic arguments in its kind of favor. So I've written in other contexts about the hesitancy of environmental groups to really substantively engage in economic arguments, which I think has been to their detriment in many ways. A victory in this case would help demonstrate how economics can improve environmental decision making and really provide a good object lesson for environmental groups interested in using economic arguments in their advocacy. Also, if the court decides the option, specifically the options argument in favor of the center, it could kind of have consequences in other contexts. So as I mentioned, right, option value is relevant where payoffs or costs are uncertainty, investments are irreversible, and we gain information over time. That describes many, many natural resource contexts and many environmental contexts, right? It can include issues like fracking, it includes issues like climate change. So a favorable decision in this case could extend out and promote sound environmental policy in a variety of natural resource and environmental contexts. Okay, so with that, I will end, and I hope to take any, or happy to take any questions, comments you guys have.